Howdy, my name's Brian Foley. I'm a criminal defense attorney and I'm the managing partner at Houston Criminal Defense Attorneys PLLC. We're continuing our overview of the Texas Penal Code. We're on Chapter 2, and that is burden of proof. So let's talk about it. Chapter 2, Section 2.01 says burden of proof beyond a reasonable doubt. And this is the burden of proof for all criminal cases in the state of Texas. It says all persons are presumed to be innocent and no person may be convicted of an offense unless each element of the offense is proved beyond a reasonable doubt. The fact that he has been arrested, confined, or indicted for or otherwise charged with the offense gives no rise to an inference of guilt at his trial. And so this is, one of the pinnacles of American criminal jurisprudence is this fact that people are proved beyond a reasonable doubt, right? The facts have to be proved beyond a reasonable doubt in order to have somebody found guilty of a criminal offense. Let's talk about some of the other burdens of proof they have in the criminal justice system. First, we would have, preponderance of the evidence. That's 50% plus one. That is the standard that people lose money on in civil cases, like a car wreck. If you think one guy's at fault, 51%, then they're liable, that person loses, right? That is not true in a criminal case. You have to prove it beyond a reasonable doubt. So the next step up really is clear and convincing evidence. That is the standard to take kids out of a home when there's been some type of allegation of child abuse, termination of parental rights. It's clear and convincing evidence that, that issue's present and that it ought to be, severed. Well, that is still not beyond a reasonable doubt. It is not beyond all doubt. It's not beyond all possible doubt. It's not beyond a shadow of a doubt. It's beyond a reasonable doubt. And that is the standard that we have. There used to be a definition that was given, but they no longer give that definition. It was something like, the type of proof that you would want in your most important affairs to make like a really important decision. And they tried to kind of equate it to like buying a house, but that's really not sufficient, I don't think. It is the standard by which you want to live in a society and the level of power you're willing to give the government to destroy someone's life, right? Because a criminal conviction really does that, destroys somebody's life. So they have to be able to prove the case absolutely, right? Beyond a reasonable doubt. There are no reasonable doubts left in your mind. You know that it's true. There's no chance that it's not, right? That is the proof beyond a reasonable doubt. Okay, second section here under burden of proof is what we call an exception. So the last three sections here are going to be different types of defenses, as we would call them. The first type of defense to a criminal charge that they list in the penal code here is exception. And they identify how you can tell when an exception is going to apply in some criminal statute. It says, an exception to an offense in this code is so labeled by the phrase, quote, it is an exception to the application of blah, 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 whatever crime. And this is what happens. The prosecuting attorney, meaning the state, must negate the existence of an exception in the accusation charging commission of the offense and prove beyond a reasonable doubt that the defendant or defendant's conduct does not fall within the exception. Okay, section 2.03, this is called defense. A defense to prosecution for an offense in this code is so labeled by the phrase, it is a defense to prosecution. And what happens when there's a defense to prosecution? It says the prosecuting attorney is not required to negate the existence of a defense in the accusation charging the commission of the offense, right? So you don't have to just say, it's not really part of the elements of the offense, it's something separate. The issue of the existence of a defense is not submitted to the jury unless evidence is admitted supporting that defense, okay? If the issue of the existence of a defense is submitted to the jury, the court shall charge that a reasonable doubt on the issue requires the defendant to be acquitted. So that means the prosecution has to prove that it does not, that defense does not apply beyond a reasonable doubt. Okay, the next one is affirmative defense. An affirmative defense in this code is so labeled by the phrase, it is an affirmative defense to prosecution. And it says here that the prosecuting attorney is not required to negate the existence of an affirmative defense in the accusation charging commission of the offense. So you don't have to say they committed assault And by the way, it wasn't self-defense. You have to wait until that issue is brought up at trial. The issue of the existence of an affirmative defense is not submitted to the jury unless evidence is admitted supporting the defense. So it doesn't go to the jury unless there's evidence there. So we call that the burden of production, okay? You have to produce some evidence that shows that it ought to go to the jury. Now, this can be done through cross-examination of state's witnesses. You don't have to take the stand to get an affirmative defense. Self-defense is the most common affirmative defense. And then it says the issue of the existence of an affirmative defense is submitted to the jury. If the issue is submitted to the jury, the court shall charge that the defendant must prove the affirmative defense by a preponderance of the evidence. So we've got the burden of production and persuasion. So let's look back at defenses, right? It says the issue of the existence of a defense is not submitted to the jury unless evidence is admitted supporting the defense, okay? That is the burden of production. But you see, the burden of persuasion is if you have some evidence of a defense, then the prosecution has to disprove it beyond a reasonable doubt. Well, that's not true in an affirmative defense. In affirmative defense, it says the issue of the existence, if the issue of the existence of an affirmative defense is submitted to the jury, the court shall charge that the defendant must prove the affirmative defense by a preponderance of the evidence, okay? And then basically the prosecution then has to disprove. If you've proven it by a preponderance, then the prosecution would have to rebut that. They could rebut that and disprove it beyond a reasonable doubt. So that probably doesn't make much sense. The way this really works out is the jury listens to the argument about self-defense, and if they think you were in the right, they ignore all this language and they do what they want to do. If they think you're in the wrong, they do the same thing, and there's not really a whole lot to be done about it unless a juror says specifically that we ignored the jury charge and kind of did whatever we wanted to do. That's the way it works in the real world practice. You know, for all the law professors out there, sorry, but that's kind of how it works. Then section 2.05 is on presumptions. If you thought that the last sections I read to you were confusing, get a load of the 2.05 presumption section. This is like mostly, there's different financial crimes and things like that where these presumptions will exist. It'll say like, you know, if somebody failed to pay off a note for hindering a secured creditor, then there can be a presumption that it was done to defraud, that it was done with the intent to hinder the secured creditor. It's basically if a crime is too complicated that they think they really couldn't prove what they need to be trying to prove, the statutes will sometimes include these presumptions. And I don't think juries do much with these at all. I think they get told you can presume XYZ with all these rules, and then again they just kind of do what they think. They'll evaluate the evidence and decide, did the person mean to do it? If they meant to do it, we'll find them guilty. If they didn't mean to do it, or there's a chance that they didn't, you know, because they have to prove it beyond a reasonable doubt. If your attorney is being effective for you, then the jury would find you not guilty because they're not going to meet these elements, even with all these presumption rules. Let me read one just to show you how confusing it is. Okay. Except as provided by subsection B, when this code or another penal law establishes a presumption with respect to any fact, it has the following consequences. If there is sufficient evidence of the facts that give rise to the presumption, the issue of the existence of the presumed fact must be submitted to the jury unless the court is satisfied that the evidence as a whole clearly precludes a finding beyond reasonable doubt of the presumed fact. And if the existence of the presumed fact is submitted to the jury, the court shall charge the jury in terms of the presumption and the specific element to which it applies as follows: that the facts giving rise to the presumption must be proven beyond a reasonable doubt, that if the facts are proved beyond a reasonable doubt, the jury may find that the element of the offense sought to be presumed exists, but is not bound to be so found. Right? So that's saying you can presume that something is true only if the prosecutors can prove it beyond a reasonable doubt. And if there's facts that show that it could be presumed, then the court, if they determine it can't be proved beyond a reasonable doubt, then the court shouldn't submit the presumption anyway. Do you see how, what good is that to a regular person on a jury trying to figure out what to do? The way it's used is by a prosecutor just saying, you can presume that's true, and then maybe the jury does, maybe they don't. But if you get into here, it's always going to say that if you have a reasonable doubt about any of the facts that are the basis of the presumption, then you can't use the presumption, right? Everybody's confused by this. Even if you're a lawyer watching this, it's easy to get confused by this. But, that's what it says. There is a different rule for when the presumption favors the defense. It's a little more helpful. It's probably still as confusing, and it gets used in just the same way. If we've got it on our side as the defense, we're going to be arguing that the presumption, all the evidence is there, and we're using that presumption. But so looking at that one, it says, even though the jury may find that the presumed fact does not exist, the state must prove beyond a reasonable doubt each of the elements of the offense charged, right? So even if the jury rejects your presumption, then the state always ends up with the burden to prove their case beyond a reasonable doubt and prove the facts that lead to the presumption beyond a reasonable doubt. So what good is that? I don't think it's a whole lot of good for anybody. The real elements to keep out of Chapter 2, if you're going to be a practicing lawyer in criminal law, is you need to know what a defense and an affirmative defense is. And you need to understand that for an affirmative defense, you as the defense attorney are going to have the burden of production and persuasion. And shout out to my criminal law professor, Charles Bubany, who I remember to this day talking about the burden of production and persuasion. Those terms are not used in the statutes here. That's what I remember him describing to us. So anyway, this has been Chapter 2 of the Texas Penal Code. Thanks for tuning in. If you liked what you saw, don't forget to like and subscribe. Thanks very much.